how can we address the issue of costs? Now, this has always been a contentious issue in practice where we have no contingency fees. What we have is a practice direction which sets percentages based on where your matter is resolved. If it goes to trial, if it settled at a PTR there, I think it's 45, 55, 75, 100% if it goes to trial. If it is liability is admitted and it goes to assessment of damages, you get 60% of your costs. Now, don't leave here thinking that 60% of costs is 60% of the assessed damages. It's not 60%. For example, $1 million claim resolved at a PTR would be around $60,000 to $65,000 in fees. If one were to look at the 25 to 40% which certain practitioners charge of the award, you can do the math and understand the distinction, why maybe some 20% is going forward. So it begs the question of information and who is responsible or who is going to hold that baton or that torch to educate the public. Is it the egg and chicken? Is it going to be the insurance company or is it going to be the law association? Is it going to be the mediation board? It is going to be the dispute management association, a recently formed mediating body. Someone needs to start educating the public on what attorney fees are, what it ought to be, what are the bands. So the interests in the mediation, in costs, can be resolved simply by the parties understanding that an award of asking for $100,000 includes $50,000 costs, but the assessed cost is $5,000. So what I'm asking for is not reasonable, but it puts attorneys, mediators to task. I just want to leave it one last point, and this is moving away from the issue of the statistics, the numbers, costs, and what we have heard is that running down action is a fairly complex area, practice area. The issue of evaluative versus facilitative mediation is something we will need to consider going forward to assist and encourage parties to realistic settlements, longitudinal timelines, because we are at our infancy in mediation in Trinidad, setting fixed rules that say you must complete your mediation in a certain time may not be the best thing for us. Recognizing that we are not having compliance with the practice directions may need to give us time to go back and say, look, how much time do you need to comply with the practice direction to disclose, and then come to mediation. We also need to look at where matters are filed on the verge of a limitation period expiring, and the rules provide that you are exempted from certain disclosure and pre-action protocols. And we need to consider that, is this a tactic, or should we now address that by saying if you file on the heels of your limitation day, we will extend the time for you to go back and comply with the practice direction, so we don't have bold and bare pleadings. on that note, I would just like to thank you all for listening to me. I hope I haven't burdened you with some of my not entertaining part of personal injuries. But I do welcome your feedback and questions that you may have for me later on. Thank you very much.
Thank you, Krishna, for emphasizing the importance of disclosure and preparation, for sharing with us some of the valuable provisions of the civil procedure rules and the importance of educating the public on the importance of the reduced cost of mediation versus litigation, and for provoking us to think about whether the evaluative versus the facilitative technique is something to consider when we are conducting insurance mediations as mediators. Thank you very much for that, Krishna. Our final presenter is, I don't know if to say deputy judge, or just Louis. Louis Resnick is a mediator and arbitrator with ADR Chambers. He is a deputy judge of the Small Claims Court, Toronto. He has been appointed an arbitrator by the Financial Commission of Ontario and has a whole host of qualifications that I'm not going to go into at this time because we are running out of time. So without further ado, please welcome Judge Louis to share with us.
Not Judge Judy, right? Right. Good afternoon, everyone. You can hear me from here. I'm too lazy to walk over there. Everything my friends have said, I agree with. And it's interesting because we come from different jurisdictions. And of course, that informs and influences how we conduct mediations. Because we can't conduct the mediation in an abstract. We can talk about it in a theoretical sense, but when you put it into practice, you have to work within the jurisdiction you're working in, obviously, and the prevailing law and the circumstances and attitudes and approaches that come to the mediation. But a few comments. I have no PowerPoints. I'm technologically challenged. Number two, we really don't in Toronto and in Ontario, and I'm not familiar with really having disreputable insurers. We have some that take a harder stance. There's some who adjust claims differently than others. Some are just, as I spoke earlier about how the Canadian Medical Protective Association has a policy. Some insurers have a policy that certain claims of a certain nature, of a soft tissue nature, they're going to take to trial, or they're not going to pay, and we have a different approach. And that varies from insurer to insurer to insurer. In other words, they'll take that approach, they may maintain it for a few years, they may go to trial and get hit a few times with large awards against them, and they'll recalibrate, and they're more palatable, and they're more accommodating. And some other insurer and some president of that company who's looked at the numbers takes the approach that we're going to be difficult. And so it goes. But I would never say that any of them are really disreputable, but they are difficult. Because they are not your insurance company. They're the other driver's insurance company that you're suing. They owe you no duty of good faith. So you didn't buy a contract from them. You're suing the other driver and asking them to pay on his behalf. But as I said, you have to know where you're coming from vis-a-vis your environment. There are two major types of personal injury cases that arise in Ontario. One is the motor vehicle. We have a population of 6 million people, cluttered, congested highways, lots of bankrupts. Right now, we're in the winter months. There will be 30, 40, 50 car pileups because as you're driving on the highway from one jurisdiction, from one city to another, you may enter a whiteout. A whiteout is you see nothing in front of you because it's just snow. And so you're praying to God and you're crossing your hands and your fingers or whatever that the vehicle ahead of you does not stop suddenly or veers off because they hit an ice patch. Because then what happens is that everyone that follows behind slams in. In the summertime, because we don't have any of this winter, although it's short this summer, the winter conditions, people tend to drive a little bit faster and are not as attentive. So we have a lot of pileups. The other type of injury is, of course, occupier's liability, people who own establishments and people who fall, slip, injure themselves in those establishments. Of course, there's other types of injuries, but those are the two predominant ones. All of those cases, if they are not settled, when I say all, I'm saying virtually 90% plus, if they don't settle, will be tried, not by a judge. Jury notices are filed unless there's some legislative prohibition against the jury notice. So it's a different environment. It's unpredictable. The juries are comprised of 6 people. As I tell the people in my mediation, think of 6 people walking around a food court, plucked out, put in the jury box, and they're going to decide whether they like your case or they don't like your case. They're going to decide whether they like you or they don't like you based on their own background. What do you know about them? You know their name, you know their occupation. That's where you're coming from. So those are the people. Now, there's talk of eliminating the jury, but as I speak today, and the jury's system has persisted right up to the present time. So that's a leveler. Plaintiffs like it, and the insurance companies like it. Because in the end, when you get to the jury box, it all depends on whether the plaintiff is liked or not liked. And that is such unpredictable. So a lot of times the medical reports may read the same because a fracture is a fracture and you can put an x-ray up and show it. But when you're talking about a soft tissue injury, it's strained muscles and ligaments. They will never show on an x-ray. It's the credibility. And that then depends on how credible the witness is or isn't. It's like putting on a play like Romeo and Juliet. It's 500 plus years old. Everybody knows how it ends. A lot of us know the dialogue. But not every production gets a good review. Some close up the next day, and some have long extended runs. Same play, just you don't know the outcome. And that's a tremendous leveler. So besides the motor vehicle and the occupier's liability basically is, we're in the general tort law that we all, I think, except from the common law, it's been codified in Ontario with the Occupiers Liability Act, which basically says that the occupier, as defined in the Act, has a duty to take reasonable steps to make sure that the place is reasonably safe under the circumstances. And usually there is, you heard the countervailing argument that either all reasonable steps were taken. That means just because someone fell doesn't mean that there was an actionable wrong. Something could have happened a minute before they fell, and it wouldn't be reasonable for them to respond within a minute. So, or there's what we heard before, the contributory negligence element. The plaintiff should have noticed it, seen it, taken due care, walked with due care and attention, and wasn't paying attention to what was noticeable, and they share in the liability. The other aspect is of course, motor vehicle. Now that will take days because it's a hybrid of a no-fault system and a tort system. And the no-fault system, of course, you don't need little vehicles or toys to describe how an accident happened because it's no fault. Irrespective of who's at fault, your own insurance company has certain obligations to you. And those are very potentially generous if you can force the insurance company to pay. So at the end of the day, when you're a plaintiff, you are faced with a tortfeasor and their insurance company, and you're faced with, in a motor vehicle situation, and with your own insurance company, who has gotten a little bit tired in sending you money. And so that's the debate and dichotomy. But I was listening to what my friend said about disclosure. When are mediations generally held? As I said with the medical malpractice, it's done later than sooner. Because if you do it in the beginning, you just don't know the full extent of the injury and the full extent of the loss. Plus, some lawyers are lazy and some are industrious. But if you want to move this case to trial, you've got to kickstart first the mediation, because you can't get to trial. So all the other preliminary stuff has been done. What is the preliminary stuff? All the exchange of documents have been exchanged. Sometimes they're not up to date. That's the problem. And counsel sometimes may not want to spend the money to get an up-to-date report. And that's a problem, because if you're at mediation